Alrighty. Hello, class. We are doing presentation 2, which involves myself. I'm Courtney, and my partners were Kelly and Christina, and our jurisdiction was Kentucky. The question is, Jamal is suing his ex-girlfriend for intentional infliction of emotional distress. He claims that she was such a relentless, tormenting sadist that he now suffers from post-traumatic stress disorder. In discovery, his ex serves production requests asking for all Jamal's psychotherapy records from his psychiatric visits over the past 5 years. Jamal objects. Is his ex entitled to those records? So now I will proceed to Westlaw. I already have my jurisdiction set for Kentucky. So first I would start off by saying, what are the elements of intentional infliction of emotional distress? Oh, sorry, made a typo. Alright, so I scrolled down because I wanted to find a case that had like no negative treatment. And I scrolled down to this case here. Gobel versus Arnett. And it gives a good description. Just hit this. And right here, it says the following elements must be established to support a legal claim of outrage. The wrongdoer's conduct must be intentional or reckless. The conduct must be outrageous and intolerable in that it offends against the generally accepted standards of decency and morality. There must be a causal connection between the wrongdoer's conduct and the emotional distress, and the distress suffered must be severe. And here I have, my Blue Book citation. My Blue Book citation is here, and it's the exact same quote that I just read. Now, I will proceed back to Westlaw. And the next thing I searched, I looked up psychotherapy records within the same paragraph as discovery methods. And I went to statute and court rules. And this statute here, which explains how discovery methods work within Kentucky. And it says parties may obtain discovery by one or more of the following methods: dispositions upon oral examination or written questions, written interrogatories, production of documents or things, or permission to enter upon land or other property for inspection or other purposes, physical and mental examinations, and requests for admission unless the court orders otherwise under Rule 26.03. The frequency of use of these methods is not limited. And here, in my PowerPoint, here is my Blue Book citation. And this is the exact quote that I just read from Westlaw. Next, I keep going back. Next, I just looked up psychotherapy records. By itself, I went back to statute and court rules. And there's actually a statute that talks about the psychotherapist and patient privilege. Here, and I have a more in-depth version on my PowerPoint, and it talks about how a psychiatrist is a person licensed by the state of Kentucky or by the laws of another state to practice medicine, or reasonably believed by the patient to be licensed to practice medicine while engaged in a diagnosis or treatment of a mental condition. A communication is confidential if not intended to be disclosed to third persons other than those to present the further interests of the patient in a consultation, examination, or interview, or persons reasonably necessary for the transmission of the communication, or persons who are present during the communication at the direction of the psychotherapist, including members of the patient's family. And now, my partner Kelly will continue with more binding authorities.
It's Kelly, and I'll be going over the third binding authority. In Westlaw, I'm going to go ahead and start over here and go back home, show you how we got there. We did locate a rule of law, and how I found it is I typed in psychotherapist in the same sentence as medical records, and I believe it pulled up about 26 cases. But I wanted to see if there's anything a little bit further, if there's any statutes or court rules. And when I did that, I came down and saw that there was a psychotherapist patient privilege rule. And that falls under the Kentucky Rules of Evidence, and it's number 507. And as you can see, there's quite a bit of information with it. It defines what a patient is, what a psychotherapist is, how the communication is deemed, what an authorized representative is, or who an authorized representative is, the general rule of privilege, and then there are some exceptions. And I'm going to flip back over to the presentation so that we can go over that part a little bit more. So in the state of Kentucky, a psychotherapist is a person licensed by the state of Kentucky or by the laws of another state to practice medicine, or reasonably believed by the patient to be licensed to practice medicine while engaged in the diagnosis or treatment of a mental condition. Communication is considered confidential, is not intended to be disclosed to third persons other than those present to further the interest of the patient, and that includes the consult, the examination, or the interview. And it also includes persons reasonably necessary for the transmission of the communication, or persons who are present during the communication at the direction of the psychotherapist, and that includes members of the patient's family. On the following screen, we went over what the general rule of privilege is, and that states that a patient or the patient's authorized representative has a privilege to refuse to disclose and to prevent any other person from disclosing confidential communications made for the purpose of diagnosis or treatment of the patient's mental condition between the patient's psychotherapist, or persons who are participating in the diagnosis or treatment under the direction of the psychotherapist, including members of the patient's family. Now, where we got interesting for us is the exceptions part. There are 3 exceptions to the rule. The first one is obviously if the patient is deemed to have mental illness and needs to be hospitalized, they are able to pass on the records for that. The second exception is if a judge finds that the patient, after having been informed of the communications would not be privileged, has made communications to a psychotherapist in the course of an exam ordered by the court, provided that such communications shall be admissible only on issues involving the patient's mental condition. And the third exemption, which is really helpful for us and that we want to focus on, is if the patient is asserting that patient's mental condition as an element of a claim or defense, or after the patient's death in any proceeding in which any party relies upon the condition as an element of a claim or defense. So that rule was helping us out with Jamal and his girlfriend and the post-traumatic stress disorder. And now I'm going to go ahead and pass it over to Christina.
All right, so this is Christina, and I'm going to be sharing with y'all what we found about the scope of discovery according to the Kentucky Rule of Civil Procedure 26.02. So I'm just going to show you how I found that real quick. So I'm going to go over to Westlaw, and as you can see, my jurisdiction is Kentucky. And what I did was I typed in privileged connector P and then discovery, since I was interested in how like privileged documents relate to the discovery process in Kentucky. So I'm going to click search. And so obviously it pulls up cases first, but I was really more interested in statutes and court rules. So I clicked on that, and CR 26.02 is the very first one that pops up. So I just clicked on that and read through it, but the main thing that relates to what we're talking about is the very first one right here. So I actually have it in the PowerPoint. So it says, in general, parties may obtain discovery regarding any matter not privileged, which is relevant to the subject matter involved in the pending action, whether it relates to the claim or defense of the party seeking discovery or to the claim or defense of any other party, including the existence, description, nature, custody, condition, and location of any books, documents, or other tangible things, and the identity and location of persons having knowledge of any discoverable matter. So obviously, if we go back to the original question, it really does relate to discovery and whether all of this is allowed in discovery. So I think it was important to at least look at what Kentucky says about discovery. And under this, she is allowed to request these types of documents. However, it does say not privileged, so we did have to prove that his records were not actually privileged, which is what Kelly just previously talked about in KRE 507, and then the third point on point C. So if the patient is asserting that the patient's mental condition as an element of a claim or defense or after the patient's death in any proceeding in which any party relies on the condition as an element of a claim or defense, so that means that his records would not be privileged under that, and it is allowed in the discovery. So let's go to the conclusion. So just to wrap all this up, the question was, is Jamal's ex-girlfriend entitled to Jamal's psychotherapy records from his psychiatry visits over the past 5 years for discovery? Our answer is yes, she is entitled to the records according to the binding legal authorities in Kentucky. So just why, just so y'all have like a clear explanation, the elements of the intentional infliction of emotional distress and the scope of discovery are met. And then the physical and mental examinations are subject to discovery under Kentucky Statute 26.01, the first part. And then the records are not privileged under the exceptions to KRE 507, which is what I kind of just talked about. But that does state that there is no privilege, point 3, if the patient is asserting that the patient's mental condition as an element of a claim or defense or after the patient's death in any proceeding in which any party relies upon the condition as an element of a claim or defense, as Jamal is in fact claiming that she inflicted so much emotional distress on him that we can go back to the question itself. That she was so just relentless and tormenting that he now suffers from post-traumatic stress disorder. So he is claiming that, however, his records are not privileged, and so she would have access to that, according to all of these binding authorities that we found in Kentucky. So thank y'all so much for watching, and please leave any comments or questions below.